Hello and welcome. This is the Nevada Legal Services presentation of a small claims court consumer education class. And we are joined by our guest host, Jean Paragary. Jean, thank you so much for joining us today.
Oh, you're welcome. It's nice to be here.
Thank you. Again, this is a presentation from Nevada Legal Services. Please be advised that nothing that you see today creates an attorney-client relationship in any way and is to be used only for educational purposes. But thank you, and I will go ahead and hand it over to Jean.
Are there people on the call?
We have 2 viewers currently.
Welcome. Again, my name is Jean Paragary. Are you able to see me right now? All I see is a presentation of slides. Can you see me, or do you just hear my voice?
I believe that the presentation is up, not your, just the slides right now. I will go ahead. Oh, would you like me to start your video?
Sure.
Okay, I just went ahead and asked to start your video, so you should see an option to be able, there you go. All right.
Okay, so you can see me. Yes.
Yes.
This is weird and awkward. It's our first time, my first time doing it.
No, thank you for bearing with us, everyone.
Yes. So again, my name is Jean Paragary. I'm a local attorney. I have been practicing here in Reno, where I was born and grew up, for almost 30 years now. My most recent experience has been with a local corporation for the last 22 years. But I have lots of experience in at least civil actions, not so much small claims court, except for when I was a participant in small claims court. And that was when I was in college, and I was hit by another vehicle and they didn't pay my deductible, and I sued to get that. So I think that the insurance normally covers that now and goes after that for you. But that was my introduction to small claims court, and I've been there a few other times since then. We can go ahead and get started with slides. Okay, so this class is designed to give you an introduction overall to this small claims court process. There's a focus mainly on Washoe County and Clark County, but several areas, other areas have their own, like Carson City is the next closest one, I imagine, Fernley, those sorts of places. Would it be helpful to know where the viewers are residing?
If anyone wants to have any specific jurisdictional information, please go ahead and chat that in the live chat. Otherwise, we can just see if anybody has any specific questions, and I'll let you know as questions come through.
Thank you. So we're going to go over that. Small claims court is a division of, usually, at least in Washoe and in Clark County, the justice court. It's designed for people who have claims against each other that where attorneys aren't involved. So there's a lot of help and instruction that the courts provide on their website and in person, although right now, due to COVID-19, the courts aren't open to the public, but you can still file claim process moving and heard. These are designed to just seek monetary damages, not injunctions. And injunctions are something to like prevent something such as a protective order, where someone can't convey property or something like that in this instance, since it's a civil action. So it's just for monetary damages. A person filing a lawsuit to seek money damages would be called the plaintiff or the business. So it can be a business, a local business that's filing to seek damages against another person. That person who's getting sued and is called a defendant. So here cases would be heard by one of the local justice of the peace or a referee. Next slide, please. Can you guys still hear me? I'm wondering if we can move the slide. Oh, okay, here we go. So this is an overview of the process. And first, if you're seeking to look at small claims court for relief, you should decide if you should file a complaint. To do that, look at all the information you have. Like if it involves someone owes you money, look to see what information you have. Do you have a signed promissory note or a contract? Do you have, what other information do you have that would support the amount of your claim and the underlying basis of your claim? You should send the other side, the person you're seeking judgment from, a demand letter. We'll give you an example of that coming up. But basically a demand letter would be, hey, remember how you borrowed that money from me? You only made a couple payments and you still owe me X dollars, please pay. If they don't pay, then you can file your claim in the justice court or small claims court. To do so, they have all kinds of forms on the website that are easily available and easy to fill out. But you file the complaint, you'll have your complaint served, and this has to be done, at least in Washoe County, by a licensed process server, someone independent from you. Served means the defendant is notified in person of the lawsuit and the basis of the lawsuit and the complaint you file. In Reno and Las Vegas, it's mandatory to go to mediation. So this is a process before you see the judge, from a local mediator who will hear both sides of your side and the defendant's side and see if he can or she can get you to agree. And we'll talk more about that later. If you can't agree on a settlement or a resolution, then the court will set a date and you'll go to court and present your case, and the judge will decide who wins and who loses. If the outcome is not good for you, or if it is in favor of you and the defendant likes it, there's a basic, you can appeal that to another, to be heard by someone else. We'll go over that in more detail later. And also then if you win and there's a judgment, then you can, you'll have to execute it. It's the court can't enforce it. They just issue an order, but you'll have to figure out how to get it paid by the defendant if they don't pay you. Okay, so now we look again about when you file your claim, make sure you have a good case. Who are your witnesses? What documents support it? There may be things like texts and things you don't think about, emails, signed documents, those kinds of things. Who are the witnesses? In small claims court in Washoe County and in Clark County, the claim has to be $10,000 or less. If it's more than that, there's generally a more formal procedure. Usually attorneys are involved. And if it's over 20 or 15,000, I guess, it would go to a different court altogether. You'll also want to make sure that the defendant may be able to pay you. Do they have a job? Do they have any assets that are collectible? And we'll go over more than that because it's going to take some time and it's going to take some costs, you're going to have to come out of pocket to do filing fees. So you'll want to make sure that it's worth your time and expense to go about doing this. There's also a time limit when you can file. It's called a statute of limitations. If that statute of limitations has expired, then there's no point in going to court because they likely won't hear it. There's some exceptions to that. And so, for example, the statute of limitations for a written contract, to sue on a written contract that the defendant hasn't paid is 6 years. And if it's 7 years, you might not be able to get your case heard unless there's an exception to that. And so you'd have to consult with attorney to see if there's an exception or research it. Where are the defendants? Are they still around? Can you get them served? And should you hire an attorney? Those are all things you should consider before filing a claim. Okay, so how to file your claim. First, make sure you identify who the right defendants are. Is your complaint against an individual or a business? It all depends upon the nature of your claim, but make sure you get the right person or business and business name that owes you money. Determine the amount of your claim. You send the demand letter, you file the complaint, and then you serve the complaint. And again, we'll go over those in more detail. Okay, so step one, identify the defendants. Is it an individual or business? If there's any doubt, name everyone. You might have to find out who the defendant is. Ask friends and relatives. You might not have their full legal name. You're going to want to try to find that. There's internet searches for businesses. You'll need addresses and places where the defendant may be personally served, because you're going to have to know where they are and where they reside or work. Business owners, there's some resources here. City of Reno business license, Washoe County, Secretary of State. Washoe County Assessor has property records if you want to see where people live. So that's how to find them. You'll also want to make sure that where they work or reside is within the jurisdiction of the court hearing the case that you want to file. So if you believe they live in Reno and want to file in Washoe County in the Reno Justice Court, you'll want to verify that either through the post office or the county assessor to make sure that the address is within the city of Reno or Washoe County. Next slide, please. Okay, again, determine the claim amount. Make sure you find receipts and estimates, witnesses, whatever you can find to support the amount. Again, up to $10,000, and certain costs, court costs and stuff are recoverable if you prevail. The defendant can also, if they believe that you owe them money as well, they can file a counterclaim, and their costs, if they recover against you, may be available to them too. So that's another risk of filing. Send a demand letter. The best practice would be to send it certified mail, return receipt requested. The post office have those forms. Make it professional and polite. And the audience isn't just the defendant who you're probably upset with. The audience really is the court or the mediator. And so make it polite and professional, and lay out what they owe and why. It should include the amount of money you seek, the reason why you're entitled to that money. Give them a certain amount of time to comply. 10 to 14 days is a good guideline. And let them know that if it's not resolved by that date, that you intend to seek relief in small claims court. Here's a good example of a letter. You'll see in the introduction, it says the amount that's owed, that it was due to the defendant borrowing money. Even though they agreed to pay, they didn't. For example, you could see if you have a copy of the check where they made payment, or your bank record showing they made payment, something showing that you lent the amount and the payment amount. Those are all good proofs to have, as well as if there's people who were present when you lent the money, that's a good witness to have. Here's you said you had tried to call, but if you also sent emails or text messages and the defendant responded, you'll want to make sure those are all, you have all of those, and you look at those to make sure that, it didn't say anything like, I forgive you and I won't seek this money. You want to make sure that, if there's anything saying that the defendant said, yeah, I'll pay you, I'm sorry, I haven't paid you yet, but I understand I owe you this, I'll pay it to you. Those are all good proofs to have for court. Okay, the next step then, if the defendant doesn't pay you, here's how to file your complaint. The forms are, again, available on the court website in the jurisdiction that you'll want to file. So Washoe County or Clark County, Carson City. Those forms are there, and it's just an explanation of why you are suing them, what you're asking for, plus costs. Attach evidence to support your claim. This is required for vehicle cases in Sparks. There's a civil cover sheet also in Sparks, and there's a worksheet form in the city of Reno. It also has information about where the defendant lives, those sorts of things. So you'll want to know where that is. Those are all available in those forms. Yeah, you have to show that the defendant lives or works or does business in that site. So for example, if they live within the city of Reno, you can file in Washoe County. But even if they don't, let's say they live in Carson, but it was someone who came and did some shoddy work at your house or something, and they did work in Reno for you, you could still sue them in the city of Reno in Washoe County. And they also do business there. But if they work, like if they have a job and report to work in the city of Reno, you could serve them there too, and use the Washoe County system to file there. Here's an overall complaint process. This is on the both the Washoe County and the Clark County sites too. They all have these processes, which is easy to follow. And so in small claims court, once you do all the filings and you have it served, then the next process that kicks in, where there's a mandatory mediation. And here you and the defendant should show up at the justice court to have to work with a mediator to see if you can settle and resolve the case. If you both attend and reach a settlement, then the case will be dismissed, and you can this case doesn't have to proceed to a judge. If the defendant doesn't attend mediation, then you will get a default judgment. So you'll get a piece of paper in an order that says that the defendant owes you your $1,300 from that they didn't pay from the promissory note, the borrowing. If you both do attend, and the settlement is not reached, so you can go and mediate. It's a good time to see what the other side has to say. You'll find out what your strengths and weaknesses are in your case, but you don't have to reach a settlement. So if you decide, no, I'm not going to settle for less, or I believe my case is strong and I want to go forward, I want all of it, then you can say, no, I'm going to walk away and not mediate, and I will go to the court instead. So in that regard, the court has a date set for you. You bring evidence and exhibits and witnesses, but what you do is first file with the court the paper evidence that you have and want admitted. Then the hearing's held. Again, if the defendant doesn't show up at this point in time in front of the court, a default judgment is entered in the plaintiff's favor. If you don't show up as a plaintiff, then your case will be dismissed and there'll be judgment for the defendant. And if you, either side, you or the defendant disagree with the court's decision, if it goes to trial, then it may be appealed to district court within a very short time period, just 10 days. Again, there'll be more filing fees and costs. Okay, here's how to actually file your complaint. Reno has e-filing. You could also do it in person, except for COVID-19 right now. And I think they have another process you can do it and register online. Their jurisdiction includes not only the city of Reno, but these other areas. Again, there's a small claims affidavit in order, a worksheet. You have to sign the affidavit in front of a notary or the clerk at the courthouse, which again is closed right now. You have your return receipt postcard and a filing fee. The filing fees are on a sliding scale. So if it's a lower amount, if it's under $1,000, it's $66. And then as your case gets more money is involved, like $10,000, it goes up to $196. And again, a defendant can say, well, this person, the plaintiff, owes me money for this, or I made more payments than they're saying I made, and I overpaid them. If they think that you owe them money, either a reduction of what you claim or more than you owe them, they can file a counterclaim, and that filing fee, it would cost them $70 or $71, something like that. Sparks has a pretty similar process. All of those rules are available on the Reno and the Sparks website, or Washoe County, actually, it's on the Washoe County website. Next slide. Does anybody have any questions so far?
So far, we don't have any questions, but I will just remind the viewers, if you guys do have any, just add them into the live chat and we will address them during the presentation. But right now, so far, no questions.
Okay. So right now, once you file the complaint and the defendant is served all of that, there'll be a court date that is ordered by the judge. Hearing will be about 2 months out. Again, the affidavit and the order have to be served by the licensed process server or sheriff. On the website, again, the small claims website, there's a list of process servers who are licensed and the sheriff contact information. And there's a scale of fees and costs. Those are on there as well. And so then the defendant has to be served in person by the licensed process server or the sheriff 10 days prior to the hearing. And then that proof of service that's signed by the person who made the service will be filed with the court. In Sparks, the clerk provides an order with the hearing date when the application is for the complaint is actually filed. Okay, so again, the service is a delivery of a copy of the complaint to each of the defendants in person. It has to happen 10 days, 10 working days before the hearing, by a licensed process server. Not you, not email, but it's in person. There's some alternative ways to serve people, but again, you should go through the process server. They would complete an affidavit of service, and then that is returned to the court prior to the court date. Okay, serving your complaint. You serve an individual versus a business entity. It's personal service. It can be left at their home with a person of suitable age. I think that's over 18, and discretion. It can't be posted on the door, and not, you don't leave it with children. And the licensed process servers, they're familiar with those rules. Serving a business is a little different. There's businesses have registered agents usually, and you can determine who their registered agent is by looking at the Secretary of State websites and typing in that legal entity business name. If the registered agent isn't valid, you may be able to serve certain corporate officers or the Secretary of State. And a domestic corporation may be sued for up to 2 years after it's out of business. You can still sue a corporation that went out of business within certain parameters. Again, the license process server should know the rules on how to serve. And then the question about 2 years after it goes out of business, you can look at, here's a reference, Nevada Revised Statute 78.750, which would explain more information also about serving companies that have gone out of business, if it's still okay to serve them. So once your complaint is served, you're going to be wanting, or if you're served with a complaint, a defendant in Reno doesn't have a requirement to file an answer. But again, the defendant, if they want to dispute the complaint, they'll want to participate in mediation. That mediation, again, is a good time for both sides to see what information the other side has, see how a mediator reacts to it, see how strong a case is. If the mediation is unsuccessful, then you will want to provide all of the evidence and exhibits and witnesses information, maybe not witness information, but if they have documents that you want to go over with the court, you'll want to submit it to the court at that point in time, so you don't do it beforehand. Although you can do it beforehand. Sparks has slightly different rules. Again, they're not required to file an answer. Mediation isn't always required, just under certain circumstances involving contractors and construction remodel claims. 2 copies of evidence that you want to, if you're going to go to trial, you want to make sure you have your documents to the court prior to the hearing, at least 5 days prior to the hearing. Okay, so this goes over the mediation process in Reno. The Neighborhood Mediation Center handles these. It's confidential. It's free. You guys can agree on remedies that usually aren't allowed by the court. The agreements reached at mediation are enforceable. That person is neutral. They're not going to hear the case later. So this is your shot to where that person tries to help each party reach an agreement and a resolution. The mediation date is set by the court clerk, and it usually will happen 45 days, within 45 days of your filing of the complaint and the affidavit, and it will take place at the Neighborhood Mediation Center. Again, mediation is mandatory for all small claims court actions in Reno. You don't have to agree, but you do have to participate in mediation in good faith. So you'll want to try to reach an agreement if you can, and live with it. If you, bring all your documents, make sure that you'll have a good basis then on how good your claim is. If you don't agree, you and the defendant both, then the court will proceed to a hearing. Mediation is always available if both parties agree to go, whether or not there is a court case. So you might think about doing that before you file a court case. Some courts may let you, or you can actually go to the mediation center and see if they'll hear something prior to it going to case. Okay, so here's what may happen at mediation. If the plaintiff doesn't attend, then the court will dismiss the case against the defendant. If the defendant doesn't attend, the court will give the plaintiff a default judgment in the amount they're seeking, likely. Some courts may ask for underlying proof. If the parties reach an agreement, then the parties sign a new binding contract. Hopefully then both parties will abide by that. If not, then the case can be reopened if that mediation agreement isn't fulfilled by either side. Okay, so if the mediation doesn't work and you're unable to resolve it, the next step will be to go to court. And to prepare for court, you'll want to make sure you have your witnesses lined up. Some witnesses may say they are going to be there, but if you have any concerns about that at all, and maybe just for safety's sake, you'll want to subpoena that witness. And what that is, it's a court form which says that they're a witness at this hearing that's coming up, and you have to have them served then with a subpoena, and give them a witness fee and mileage. It's a good idea to get familiar with the court procedure. Sometimes you can attend, usually, other court hearings, things like that, or you can also read online about procedure. It's fairly informal, but you'll need the documentation and the witnesses if you need them. You'll want to be organized and present to the court your evidence. It's kind of like the people's court. I'm sure most people are familiar with that. Next slide, please. Okay, here's the process of more formally subpoenaing a witness. If you need a witness to prove your case, you'll want to talk to the witness first and make sure you know their side of the story and what they're likely to say. You'll want to subpoena the witness. It's a court order commanding the witness appear. You have to pay that witness of a witness fee, which is $25 plus mileage. And the subpoena will have to be served as well, here by the constable or the sheriff. There's a subpoena ducis tecum, and that is if the witness has documents that you don't have, then you'll want to call it a subpoena ducis tecum and specify what documents you expect the witness to bring. There may be other sorts of evidence. I'm not sure if something's broken that they have, and that's part of your lawsuit. That physical object might be something like that. Okay, here's the courtroom procedure. Again, you can observe a court in action and see if you can go look and watch the other hearings take place. Those are generally open to the public. Courts are having some hearings online. I have no idea if those are now viewable by the public or not, or what's going on with those. But again, it's easy to contact the court and see if anything's available now that the COVID stuff is happening. A lot of courts are still having hearings, and it's just a matter of what procedure they're going through, like we're doing now with Zoom. Okay, get organized to present your case. It's a good idea to prepare an exhibit book. Plaintiffs should number their exhibits by numbers, 1s and 2s, defendants by letters, A's and B's. This will be a book you put together, and you make copies of them and make sure that the judge would have it and the other side will have it. Include copies of all evidence supporting your case, all correspondence related to your case. Again, look at text messages and emails, not just paper. Make 3 copies of the original, so the judge, the defendant, and the clerk, so it's 3 copies. Reno and Sparks require prior submission of the evidence and exhibits 5 days prior to the hearing. Then when it's time to your day in court, again, it's a lot like the People's Court. Next slide. So you'll go in, you'll want to be there early. If you're not and you're the plaintiff, your case is going to be dismissed. Again, it's always important to participate if you have, or it will get dismissed, or you'll get something that you don't like. So plaintiff, if you don't appear, again, in the mediation or the case itself, if it goes to court, then your case is going to be dismissed and you will not be able to recover that money against the defendant. The defendant, if they don't appear, either at mediation or at court, then the plaintiff will usually prevail, although there may be some proofs required. Mediators are available on site. Each side gets 10 to 15 minutes, so you'll want to be prepared and practice and rehearse maybe with your witnesses. Be polite, dress well, refer to the judge as your honor or Judge Judith. Judge Judy, I wouldn't call her Judge Judy, but by last name. Don't interrupt the judge or the other side. Don't approach the judge directly, but go through the bailiff. Don't interrupt your opposing party, and dress professionally. If you're not heard by a judge, sometimes you can be heard by a referee. But the decision by a referee is called a finding of fact, conclusion of law, and recommendations. If it's heard by the actual justice of the peace, it's a decision, is an order. From those orders, there are certain instances when you can appeal. If you're the plaintiff and you lose, or if you're a defendant and you lose, you may want to consider appealing. Next slide, please. When it's a decision of a referee, you can appeal. You have 5 days to object to the decision. You do it in writing. It's a formal process, and you'll get a new hearing this time before a justice of the peace. But again, usually that process is skipped. Most cases are heard by the judge itself, not a referee. So make sure you know, if it is a referee, that it's a referee versus the justice of the peace. Because if it's the justice of the peace, go to the next slide, please. you won't have that second bite of the apple, if you will. Okay, so if it's the justice of the peace that initially heard your case, again, you still have 5 days to appeal. You'll have to do it in writing. There is a filing fee. If you're a defendant and you had a judgment issued against you, or if you're a plaintiff and you had cost issued against you, you'll have to post a bond for the amount of the judgment and for costs. You also then, it's a formal process. So you have to file a notice of the appeal with the court, a notice of the bond, and then a transcript of the proceeding. So usually when you're in court, there is a court reporter that's taking down what everybody says, what the plaintiff says, what the defendant says, what the witness say, and what the court says. And that is a transcript that will have to be ordered. It's $35 per copy of the recording requested. It has to be then transcribed. If the recording's not available, you can file a certificate of no transcript, and then you have to file a appellate brief. And that is a statement of why the facts or the law was wrong and the judge was wrong. That would be done in the district court, which is the next level court above the justice court. And it will be based upon the evidence presented in the original hearing. You can't bring new evidence. It's appeal of what happened in the justice court proceeding, not a whole new trial. Next slide, please. Okay, so if you're a plaintiff and you prevail and you have a judgment, again, the judgment just is an order saying the defendant legally owes you money. If they don't pay you, you have to figure out how to collect the judgment. There's a couple processes for doing that. You can get a writ of the execution, motion to examine a judgment debtor. There is some exempt property, some things that you can't collect on. So next slide, please. A judgment creditor is whoever wins. So again, it could be a plaintiff or a defendant. But if you're owed, then if you owe money under the judgment, then you're the debtor. If you are due money, then you're the judgment creditor. Again, you should try to seek payment first, because some of these other remedies, they're going to take time and it's going to cost you money to execute on the judgment. Okay, so a writ of execution is where you go to the sheriff and ask them to take property that belongs to the debtor. It could be wage garnishment from their work, to garnish their wages and have money taken out of their paycheck. It could be, that they do their banking at US Bank. It could be to take a certain amount out of their bank account, cash box, business income, a vehicle, real property, personal property, certain things like that that aren't exempt. Next slide, please. The other thing, if you don't know what sorts of things that the judgment debtor has, where that may be of value, you can file a motion with the court to examine the debtor, so you can find out what property they have. The judge will, or the court will, require a debtor to answer questions under oath that are asked of them, like where do they do their banking, what accounts do you have, that sort of things. And that will require, you can require them to bring certain documents as well. These are some exemptions that you can't take from a judgment debtor. So you can't take all of their wages. A certain percentage of them are exempt from that, so that they can still have money to survive on. A primary residence not to exceed $550,000 in equity. You can still record your if you're a judgment creditor, that person can record the order with the court at the county recorder's office, and it will become a lien on the property. So just because the equity, there may be equity that is not taken, there are certain times when the lien will be paid if they refinance their property or something like that. So that's always a good idea to look into recording if you're a plaintiff and you're a judgment creditor, to do that. Necessary household goods not to exceed $12,000 cannot be used to be sold to satisfy the judgment. Equity in a vehicle, certain amount in bank accounts, Social Security benefits, unemployment benefits, those sorts of things to support federal support and child support. And also 10,000, which is a wild card exemption, which I'm really not familiar with. But if you have questions about that, let me know, and I can get you the answer to that. So unpaid judgments can and must be reviewed every 6 years to see if the judgment will be renewed. A satisfaction of judgment, the judgment creditor can file with the court and say that the judgment has been paid. Affidavit of exemptions where the judgment debtor, it says, well, this is protected property, and it has to be filed within 10 days of receiving the writ of execution. So if the sheriff goes and serves it on a bank account, the judgment debtor can say that's exempt property. And you do so by filing this affidavit of exemption. Court forms, you can go again to the courthouse in person or get them online. The ones online are fillable. They're a really good resource. And they're not only the necessary ones you have to use, but there's also other resources on there regarding the procedure and the flow charts and those sorts of things. Here again are the resources you'll need. The justice courts have the sample forms available online. There's the rules of the procedure online as well. On Reno, it's the Washoe County, the Reno area. I shouldn't just say city of Reno, but the Reno area is the Washoe County website. Same with Sparks. Incline Village is Incline Village B Court, ivcbcourt.com. Carson City has a little different rules, but again, they have a really good lawsuit website explaining the small claims process and other processes they have, as does Fernley, Dayton, and Walker River area, which is in Lyon County. Okay, I guess that's it. Does anybody have any questions?
So unfortunately right now, no questions. There was a thank you, but I would like to thank you for presenting the small claims presentation on behalf of Nevada Legal Services. If anybody does have questions, please feel free to post them in the live chat. We'll stay on for just a couple, maybe just another minute. If you have any questions, to go ahead and put those in the live chat. But again, thank you very much for attending our YouTube live stream, and please like the video and subscribe if you're interested in getting more information from Nevada Legal Services. We also ask at every live stream, if you guys have a topic that you particularly want more information about, please feel free to let us know, and we will see if we can provide that information to you. But again, thank you, Jean, very much for providing this information. We really appreciate it.
Thank you.
Thank you, Jean.
All right, but it doesn't look like there are any any questions today. So I just want to go ahead and again say thank you. Please feel free to comment again about this video. And yes, thank you very much again, Jean, and have a great rest of your day.
Okay, thank you.
Bye-bye.
Bye.